texting or tweeting, you understand, but I do have some notes on here, just to show that I'm a little bit 21st century. My 14-year-old son would laugh. It's wonderful to be here. I'm privileged enough to get lots of kind invitations to talk with people all over the country, but I wanted to come back to Hull, and a seminar called Freedom to Learn was just irresistible. So thank you so much for including me in your discussions today. I am not a teacher or a scholar or an academic or an educationalist. I am, I suppose, a recovering lawyer. You never recover. Perhaps I'm just in remission. But as you've heard, I do have connections with the Academy, and it has been a great privilege to work with Janet Beer at Oxford Brookes, and now to be the Chancellor at Essex. And it's given me the opportunity to spend time with students and scholars. I've also had the opportunity to speak in many, many different kinds of schools all over the country, and to have that engagement with young people. And as a lay observer, to see the very, very different atmospheres and cultures that you can see in schools, even schools that are notionally similar in their funding or in their formal structure. And so, of course, I'm fascinated in this discussion about human rights and the educational space. Now, what do human rights and education have in common? Well, forgive me being glib, but to begin with, we all like human rights, and we all like a great education for ourselves. It's just other people's rights and freedoms and other people's great education that's sometimes a little bit too expensive. And that is my view of everybody's attitudes to politicians, the right-wing press, etc., etc. They love human rights, their own, and those of their friends, their family, people they love, people they identify with. It's just those other people over there who shouldn't have them. And that, I'm afraid, is also the attitude of some of those same elites to things like university education in particular. Of course, it's for me and for my children, but it's a little too expensive for some other people's children, so perhaps they should just go to whichever institution is local, or perhaps they should just do a course online. You know, they don't need the Dreaming Spires, they don't need to be funded and given the opportunities that are good enough for my children. So I think the attitudes are very similar in both regards. I also think that the two concepts are completely interrelated, because you can't secure people's rights and freedoms if they aren't educated about them. I can fight for the Human Rights Act and for the European Convention on Human Rights and for the Equality Act and for all sorts of other important statutes that, by the way, are currently very much under threat. I can fight for those things and we might defend them, but if people don't know about their basic rights and freedoms, they will remain a dead letter in a sealed book and not really worth anything very much at all. And equally, I would argue that you can't really have anything approaching a decent education if there isn't some respect for rights and freedoms in education. At worst, you're going to have indoctrination, and at best, maybe something you might call training, but not education as I understand it, which is about leading people out of themselves, giving them empowerment and the opportunity for critical thinking and speech and so on. That, I'm afraid, is my view of what great education would be for anyone. That's what it was for me, and so why should I want anything different for other people's children? It's always the problem, isn't it? Other people's children. Our children are nice little angels off to cello practice, and other people's children are the hoodies from hell. You'll appreciate that as the Director of Liberty, I've sometimes had to take on, let's say, causes that are less than popular for the time being. And yes, the Sun newspaper did call me the most dangerous woman in Britain. That has been an enormous honour. You can imagine, I've dined out on it, haven't I, for years. Going to different parts of the country, speaking to different kinds of audiences. It's a great icebreaker to be able to say, be afraid, be very afraid. The Sun newspaper once called me the most dangerous woman in Britain. And you get different reactions around the country for different types of audiences. But the closer you get to the city of Liverpool, the greater the likelihood that you get a standing ovation before you've even started. So imagine my consternation when the Daily Mail newspaper spoiled my fun last spring in the run-up to the general election and decided that actually now the most dangerous woman in Britain was a certain upstart, charismatic politician north of the border. And to add insult to injury, the First Minister is even a little bit younger than me. But never mind. But back to unpopular causes. I have had, over the years, more hate mail, whether by post or these days in the electronic form, when I've spoken up for young people's rights and freedoms, than when I've spoken for the rights of terror suspects. Seriously. So you go on and do a radio debate about concerns about CCTV in primary schools. I once had a debate with a headmaster about whether it was proportionate that he had installed CCTV cameras in the washrooms of his primary school. Yet more of a critical response for doing debates like that, or speaking against ASBOs for children. More criticism for that than campaigning against, 90-day or 42-day detention without charge or trial for terror suspects. It's kind of interesting observation on what pushes people's buttons, on attitudes to young people in this country. I think for some people, human rights is a dangerous enough concept without mixing it with young people's minds too. It's too close to home. It's too close to home. But fascinating nonetheless, and I hope of interest to your work and the study and potential movement that you might build through these seminars and beyond. But a little first about our human rights framework, just so that you know the basic building blocks in case it's relevant to your work. Because I don't think you can have any kind of democracy if it's not built on the foundation of fundamental rights and freedoms and the rule of law. There is a difference between democracy and mob rule or just complete majoritarianism. Let me put it like this. If I stand for election and I win power, a nice sweeping majority, if there aren't rights and freedoms, I might decide that actually the press that's a little critical of me is seditious. I might decide that my political opponents are a threat to national security, and perhaps they should be impeded in some way or even locked up. I might start to affect freedom on campuses. I might start to interfere in the independence of the judiciary and of the police. I might even get to the point where I decide that we're going through such an economic crisis and elections are so expensive that perhaps we ought to delay them a little. And very quickly, today's democracy descends into something quite different. Now that may sound alarmist, but it has happened in our lifetimes all over the world. So to my mind, fundamental rights and freedoms, ultimately enforced by independent judges and the rule of law, are the rules of the game that we call democracy. And human rights are not about unfettered freedom. How could they be? Unfettered freedom for the lion is tyranny for the lamb. And they are a carefully calibrated framework of respect for autonomy, of course, but also protection. Because ultimately the vulnerable do need to be protected from the powerful. And that is in part what human rights is about. It is a protection against abuse of power. Now it's not just that, and it's not just about law. And to my mind, for human rights really to thrive, they have to thrive not just as a legal framework, but ultimately as an ethical framework. If you go back to post-World War II framework, it begins with Mrs. Roosevelt's legacy, and that's the Universal Declaration on Human Rights. That is not actually a legally enforceable instrument anywhere. It's a set of values formulated by people slightly to the left of democratic politics, slightly to the right, proponents of all the great world religions, but also people of no religious conviction whatsoever, who come together in that unique, yet to be repeated post-war moment, and agree that if we as a species aren't perennially to descend into barbarism and war, we need to settle on some core universal values. So that's a universal declaration, and that in turn, as you know, is reflected in a number of different instruments covering different aspects of human rights and enforceable in different continents around the globe. And that includes Mr. Churchill's legacy, ironically now trashed by his political descendants, including people who write his biography and so on, but anyway, including our own European Convention on Human Rights. Now this is civil and political rights, not socio-economic and cultural rights. They're dealt with elsewhere, but this is the document that is now made law in the UK via our Human Rights Act, which the present government, when it deals with its other little problems, has promised to scrap. And just to give you a flavour of what's in there and how it might be of interest to your work, not just as hard law, it must be hard law, but as an ethical framework too, it includes Article 2, the right to life. Now that, of course, is not the right to everlasting life, because you're going to have to go to clerics or medics and miracles like that. But it is the right to positive protection of the people, and that includes the right to investigation into untimely death. So my colleagues, I have some colleagues in Woking at the moment at the Deep Cut inquest that you may have read about. And that inquest, 20 years on, probably never be happening because too many people didn't want it to happen without the positive obligation to investigate independently that is contained in Article 2. Article 3 is the right not to be subject to inhuman or degrading treatment or torture. And of course that conjures up, war on terror, ideas about extraordinary rendition and so on and so forth, and that's fair enough, but it's also the article that led ultimately to the abolition of corporal punishment for young people in schools in this country, and stopped the common law defence of reasonable chastisement being employed even as late as the 1990s by parents and step-parents who put their children in the hospital. And whatever your views on smoking and so on, there was a common law defence to offences against the person called reasonable chastisement, and there were Crown Court prosecutions that failed when parents and step-parents and others in that position argued reasonable chastisement as a defence to grievous bodily harm, not even to common assault. So that's Article 3. Article 4 is the right not to be enslaved. It's a good one to mention here in Hull. Now you think that we abolished the slave trade hundreds of years ago, but there wasn't actually a criminal offence of holding someone in servitude or slavery until 2010, because we brought action against police forces and against the UK government and got a change in the law. Article 5 is the right not to be arbitrarily detained, though interestingly, there are lawful justifications for detention, of course, in the criminal justice system and the mental health estate and so on. One of the justifications for detention is the education of minors. So it's interesting in the context of your discussions, perhaps. Article 6, the right to a fair trial, and that's in the administrative, civil, and criminal context. It's a fair hearing before something bad is going to happen to you, and I think that's a fair enough aspiration for anyone, including people in the academic environment, the school environment. It becomes very difficult to make real when people don't have access to advice or representation or indeed knowledge about the law or about the rules of any establishment or their rights. Article 8, the right to respect for your private, family life, your home and your correspondence. I might come back to that. That is incredibly topical at the moment in debates about online privacy and surveillance. You will know that the government has draft legislation called the Investigatory Powers Bill, that some of us call the Snoopers Charter. And this is something that comes post Edward Snowden's revelations and is an attempt to put all sorts of practices that were happening outside formal law on a statutory footing. And it's pretty breathtaking stuff, whether you agree with it or not. It's really quite a staggering development in blanket surveillance over entire populations rather than the traditional approach of targeted surveillance against individuals or groups who've come to concern. Article 9, I think very relevant to you, freedom of thought, conscience and religion. Crucially, the right to have the faith of your choice, the right to have no faith, and I think most importantly of all, perhaps, the right to be a heretic in any faith community, to be the gay Muslim or the woman that wants to be a bishop, or I don't know, maybe the Sikh woman who wrote the play Beshti all those years ago that got shut down after the mob gathered outside the Birmingham Rep because she wrote a play that was set in a Sikh Gurdwara and dared to suggest that a rape could happen there and all hell broke loose. Article 10 is the right to freedom of speech and expression. And like most of the rights and freedoms, other than torture and slavery, it's not an absolute right. Privacy can't be absolute. Even free speech, which is a lifeblood of democracy, cannot be absolute. If I'm inciting you to murder, or or to other serious criminal offences, few people would argue that it's not okay to criminalise that. But nonetheless, I think one should interfere with that very, very slowly and lightly. And I think that is a very live issue in schools and on campuses today. I think it's potentially under threat, perhaps unsurprisingly, from an ever more authoritarian state and government, but perhaps more surprisingly, sometimes from students themselves. You know, there's always Big Brother, but we can sometimes be less than perfect little brothers and sisters to each other. And I must confess to having some concerns about all this no platforming. I have received too many emails from very sweet and engaged young people urging me to boycott their particular academic institution because so-and-so else has been invited to speak there, or because, this was a really good one actually last term, a women's officer of a particular university wrote to me and said she was writing to all the women who were billed to speak last term, asking us not to go because not enough women get invited to speak at that university. And it was a very sweet and polite email, which I duly replied to with the suggestion that maybe she might like to rethink her strategy on feminist grounds. Because to my mind it was like the equivalent of rightly pointing out the scandal of underrepresentation of women in Parliament, responding to it by suggesting that we should all boycott the next general election and ask sitting women MPs to stand down and no women candidates. You take my point. Article 11, freedom of association. And then I think the key to the human rights kingdom, because so many rights are qualified, there are so many balances to be struck. The key to the kingdom, in my view, is Article 14, which is the right to equal treatment under the law, or we lawyers sometimes call it non-discrimination. I think we humans might call it empathy. The idea of walking around in someone else's shoes and treating other people as you'd like to be treated yourself. It's a great ethic that we find in all the great world religions and patterns of belief, in my view. And I think it's very important because, to go back to where I began, we all love our own human rights. It's other people's that are a problem. And I think this is also the way in which the courtroom and the ballot box can work together. Because the principle of equal treatment imposes on democratic majorities the obligation to care about disenfranchised minorities. So, for example, think about the way in which the most disenfranchised often suffer the greatest violations of their human rights. They're the ones who get fingerprinted or get told they have to carry ID cards or get subject to stop and search without suspicion, etc., etc. All the worst authoritarian experiments will begin with disenfranchised minorities. Who are the greatest disenfranchised minorities in Britain? Well, you know, arguably refugees, foreigners, people under the age of 18 who can't vote, and so on. And so you have these experiments in human rights violations for them, but sometimes the courts are more empowered ultimately to intervene because there's been discrimination than they would feel about just challenging a policy decision. And so it forces majorities to say, well, actually, if I don't want to carry an ID card, why should I force all people of a particular group to carry an ID card? If I don't want to be fingerprinted compulsorily, why can't impose that on the minority? So it gives some kind of greater protection to the disenfranchised. Now, perhaps a word about some of my more litigious engagements at Liberty with educational establishments. Now, I've already said I've had wonderful engagements with educational establishments as a speaker, and I've had lots of plastic PhDs, thank you very much, far more than you even mentioned. Sorry, they're honorary doctorates. Yes, I'm afraid that I only really have one proper degree. And I went to bar school, that's a sort of degree, but I only really have one proper degree, the rest are all plastic. So I've had all these lovely engagements with the academic space, but I've had some rather more litigious ones as well. I think the first was before I became Director of Liberty, when I was still in-house counsel. So this is around 2002. I represented a girl, a 15-year-old girl, who objected to the Iraq War. Outrageous, right? Outrageous, rebellious child. She objected to the Iraq War, like many millions of people in our country. And around the time of the big demonstrations, she organised a protest just outside her school in Essex. And, you know, there were homemade signs and placards, and she and some of her friends paraded around a little patch of grass in front of the school at lunchtime. And a senior teacher of the school went out and ordered her to stop, and this was not allowed. And I'm afraid that my client called her senior teacher a fascist cow. I'm putting my cards on the table here. I'm not going to sugarcoat this. She called the teacher a fascist cow because she was being ordered into school and to stop the demonstration. So as a result of this particular exchange, my client, 15 years old, in the run-up to her GCSE exams, was expelled. On the spot. Right? No warning, no trip to the headmaster's office, no, you've let the school down, you've let yourself down, you've let everybody down. None of that. None of that sort of semi-endearing stuff. Just do not pass go, do not collect £500, you are expelled, which means you won't be able to attend your revision classes for your GCSE exams, and we won't let you back onto the school premises to sit your GCSE exams. 15 years old. Now, if we go back to Article 10 of the Convention, which is freedom of expression, it's not without limits. It's not going to give a child a right to call their teacher a fascist cow, or even give them a right to organise a demonstration at school if this is contrary to the school rules. But think about these qualified rights, like privacy or conscience or speeches. They can be interfered with in a way that is in accordance with law, that is necessary and proportionate. So the question arose, was this sanctioned? Not was the school within its rights to say you can't demonstrate outside the school, not was the headmaster within his rights to discipline a child for insubordination and calling a teacher a fascist cow, but was the sanction proportionate? And you know, I'm always concerned about litigating against schools and getting young people involved in litigation. In fact, litigation is not actually my favourite sport for anyone. at all, at whatever stage in life, because it's not the easiest thing to endure as a person, let alone a young person. So obviously the first instinct was to try and get in touch with the school. Is there not a conversation to be had? Try and get in touch with the school, stonewalling, try and get in touch with the governors, nothing. There's no appeal process that's been allowed, nothing. And they just wouldn't speak to us. And the girl and her father had already been on local television. The thing had already become a bit of a course celeb. So we agreed at Liberty to represent this young girl, and we brought judicial review proceedings in the High Court. That's what we had to do. And we had a judicial review at court, and attended court with senior counsel, and the headmaster sat there, and the senior counsel on the other side. And this was all heard by a High Court judge who could not believe that this was happening. And we'd come to this, and I remember I think we sat for a couple of days in the High Court. In the morning, I'd go and sit there outside the court door, and the headmaster would turn up. And one day I said to him, it really didn't have to come to this, but it has. And I appreciate that when this is over, you're going to have to deal with this with the other kids in your school. That they've been all over the papers, and there's been a big court case. And I just said, if there's anything that I can do to help, if you want to do an assembly about, human rights and judicial review and turn it into a positive thing. But his lawyers told me off for speaking to their clients, and it was all very hostile, and that wasn't going to happen. So we had to fight it on judicial review, and the judge made it absolutely clear that this was ridiculous and needed to be resolved, and that girl was going back to school. And counsel for the school said, but if you do that, that will be the end of any discipline in the school. If you let that girl back onto the premises to do her revision classes and exams, she will crow to her friends, and that will be the end of that school as a coherent institution of learning. And so it was agreed by a sort of consent order that my client could attend for her revision classes and sit her exams, but she was not allowed to associate with the other young people at break time. She would have to eat her sandwiches in the library and not in the canteen, and she was not allowed to fraternise with them. And she'd have to obviously write an apology to the fascist cat. Sorry. And so that was agreed, and my client, we had one after a fashion, and I went back to my offices and I phoned my 15-year-old client. And I thought that I would get great plaudits and praise for a brilliant human rights litigator, but no, she was very upset. She wasn't going to be able to fraternise, and she had to write this letter of apology. I was in my early 30s at the time, she was 15, and I explained to her that I would write the letter for her and find a form of words in the way that lawyers can. And certainly she was prepared to be sorry for calling the teacher a cow. But then, can you believe it? She was due to go to school the following Monday morning, and the same headmaster stood at the school gates and barred her from entering. And the girl's father phoned me, and I phoned the solicitors for, it was a large school in Essex. I had to phone the solicitors for the school and tell them that their client was going to be in contempt of court. And if they didn't ensure that my client was allowed into school the next day, we would be going back to court to find her, and ask the court to find the headmaster in contempt of court. And then she got to go. And now, I probably dwelt on that story too much, but it's surely the opposite of everything you would want to be attempting to achieve. What have we taught? Not just that young girl, but what have we taught everybody else who attended that school about the educational space and what it should be like? And what is the government proposing to teach our young people with the imposition of the so-called prevent agenda? in schools and on campuses. Now don't get me wrong, I am not naive to threats of extremism and terrorism and so on, but and I do think that there is a proportionate role for the police and for the spooks and other appropriate agencies in targeted surveillance. I just don't believe in all this constitutional cross-dressing, forgive me, I mean cross-dressing is fine, but constitutional cross-dressing is not fine. And I don't approve of trying to turn youth workers and teachers and lecturers and professors into agents of the state, let alone surveillance agencies. And I think it's very, very dangerous to corrupt the sacred space. I think it is a sacred space that is an institution of learning by allowing people to feel uncomfortable, to come and air their views, however crazy, however extreme or radical, these words that now have necessarily a pejorative connotation. And I think that that's the way to, it's actually the way to radicalise people, not to democratise people's thinking. And I again would go back to the students that sometimes no platforming each other and just say an end like this. I don't believe in an internet age that there is such a thing as no platform. In an internet age, everyone's got a platform. It's just, do you want those platforms to become narrower and more isolated so that people just go online and talk to people they already agree with? Or do you want this kind of space where people can speak and discuss and debate and be challenged? And I know which I prefer. And in the spirit of that, I'm now going to shut up and open this up. But thank you so much for listening.
I want to say a huge thank you to Shami for that talk and for making it so relevant to the aim and the background to the project. She's very happy to answer questions and have a bit of a dialogue now. So
yes, questions, comments.
Open it up to you.
Comments disguised as questions are my favourite.
There's one over there now.
Okay,
if you'd like to stand up and say who you are.
Yeah.
Sure. I'm Julian. Can I just sit down like this?
Yeah, you sit down.
Yeah, is that cool? Hey, I'm Julian. I have a question and a comment disguised as a question. So, hey, you mentioned a little bit about democracy, and I'm really interested on what you take on, you said not just having majority ruling. My whole idea of democracy is it could be two wolves and a lamb voting on what's for dinner. And it seems like you kind of touch upon that point, but I'm just curious if you can elaborate on that a little bit more.
So democracy does not allow two wolves and a lamb to vote for what's for dinner, because the lamb has a right not to be dinner.
Okay.
And how do I justify that?
Yeah.
I think people, greater people than me, have attempted to define where human rights come from. Yeah, what's the foundation? What's the foundational thinking or thought? Now, some people, not exclusively, but some from a sort of religious kind of tradition, say, well, it comes from the idea of human dignity and the idea that human life is special and therefore each and every human life is precious, right? Every newborn baby, every newly arrived asylum seeker, and even if the majority says so, you can't just throw some people away. Even if it feels utilitarian in the moment, you can't just abandon this precious human life in that way. That's one way of justifying the existence of human rights, and that suits a lot of people. And it has a lot of force, but I've got another, if you like, a more straightforward, functional, secular, democratic regulatory justification, and it's that democracy will not last without human rights. Because if the majority votes the next election cancelled, or the majority says we're not having a free press anymore, or we're not going to have academic freedom anymore, that's the end of democracy. Democracy can eat itself, just like a free market can eat itself and turn itself into a monopoly or a gangster paradise. So you actually do need rules of the democratic game in order for democracy to keep alive.
Okay.
So should we, is it someone else?
Yes, someone else.
Yeah. Yes, please.
Helen is University. At the moment, as I understand it, Summerhill School in Suffolk is going through a situation with Ofsted where they are being subjected to the usual rules of Ofsted inspection. Now, I don't know if you're aware, but back in 2000, Summerhill went to the High Court and they were defended because Ofsted were inspecting them with usual rules. And they managed to win special sort of Ofsted situation where they had somebody go in who understood the school as very different. So the difference being, or one of them, that the children don't have to go to lessons. And they fought for their right to be different and to maintain that school in that way. And various things were put in place to allow that to be fair. And what's happened recently is that Ofsted have, and the government indeed, have evoked sort of a clause in the agreement which says that if inspection of Ofsted causes problems elsewhere, special circumstances that they get are offensive to the general inspection of all schools, then the state can go back on the promise that was made to this other school. And as a result, Summerhill now are very concerned about their ability to survive an Ofsted inspection and to continue as a school that doesn't coerce children to go to lessons. What do you think about these situations where schools go through these huge high court proceedings and all of the trouble that that causes and the expense and so on? They get a win, but then 10 years later, a little promise, a little clause is evoked that means that it was worth nothing. How can you get a proper defence of other forms of education in this country?
Well, I'm not an expert on the relevant legislation and the action, so I don't know the case and I don't know exactly what the basis of the judicial review was. And there is, I know, a lot of statute law here in the context of the regime for schools and for inspection. But just at first blush, I'm always concerned about the heavy hand of bureaucracy. And about litigation when there could be negotiation. And my instinct as a bleeding heart liberal and a human rights person is to want to respect difference. And I think that the state and the emanations of the state, like Ofsted, should be able to do their work and protect children and ensure a reasonable standard of education without deciding that one size should fit all, or that one particular model of inspection should fit all. But as I say, I don't know any more about the detail of their justification. I personally am not that bothered about, they made one promise and 10 years later they changed their promise. It's really about the substance. It's really about why it is that they have to impose one particular approach. But as I say, I probably shouldn't say any more because I'm actually speaking to it fairly ignorantly. Yes.
Another question here? Yeah.
I wonder if you could just say a bit more about the no platforming remarks which you made, because I think it's quite complex here, isn't it? Because even though I'm not a fan of no platforming, there is a balance to be maintained between freedom of expression or freedom of speech and hate speech. And in the context of what we're going to count as hate speech, which is now kind of we allow exceptions to freedom of expression if we think that it's hate speech. And what's difficult is to articulate what counts as hate speech. And we have, of course, got the, and in things like the Sex Discrimination Act, whether somebody is being sexually discriminatory is not a matter of motive. And whether certain kinds of remarks are offensive is not a matter of the intention of the person who utters the remarks. It's a matter about how, a certain group, and that's what's so difficult to formulate what group is relevant here, finds those remarks very offensive and constitutive to the building of hate speech. So if we looked, for example, at a recent controversial decision, which was the debate about whether Germaine Greer should speak given her views on trans, which are, even to a non-trans person, I find those views extremely offensive. And so it's a question of when, if we, could accept that Germaine Greer's views on trans are offensive, when the notion of offence trickles over into hate speech and therefore impacts. So I think it's not possible to simply take an opposition to no platforming. I think there has to be an acknowledgement.
I hear you, but I do think there are complexities, but I think to some extent they're overwrought. And the one right that there cannot be in a democracy is the right not to be offended.
Yes.
Now I agree with you. There is quite rightly law against discrimination, and it's very important. Discrimination against racial discrimination, sex discrimination, etc., etc., etc. And that is the law, and people should not be discriminated against. But I still say that it should be somebody's right to stand here and say, actually, that law is wrong, Shami, and you should not be protected. We've got to be able to keep having the debate. And I'm sorry, some people are very easily offended. I personally, you're quite right that there are now offences of incitement to hatred as opposed to just incitement to violence. I personally think that was a wrong turn in the law. I think that terms like love and hate, they work in literature, but they don't work in law because they're too nebulous as legal concepts. And I think that was a wrong turn in the law. And if you look back at the history of it, some of the earliest prosecutions, for example, of incitement to racial hatred were actually used against the groups that you thought you would end up protecting. So I personally would keep the criminal law very, very limited to incitement to actual violence and not incitement to hatred of whatever kind. That's different from discrimination, which is we're not to discriminate in the provision of goods and services, be they in the public or the private sector, which is the democratic settlement of which I approve, so that everybody can thrive. But this right not to be offended, I rather disagree with Professor Greer's views too. I disagree with Mr. Cameron's view. Look, I'm descended from migrants to this country, not a bunch of migrants, because it only takes two. So I find the Prime Minister's remarks completely offensive, to make my blood boil, what he said about Calais, what he said to Jeremy Corbyn in the House of Commons about visiting a bunch of migrants, but I wouldn't censor him. And I wouldn't platform him, I think the more complicated thing is sometimes that within universities and schools and other nurturing environments, people want particular safe spaces to have conversations with people who are fellow women, and I think that's, everybody shouldn't be going to everybody's party and everybody's club and everybody's seminar the whole time. But I think that's a bit different from, we will ban you coming to this university, we will no platform you, we will barrack you, which I don't approve of.
There's a question at the back there.
Hi, Alan Loftus, primary head teacher. I'm interested in your views of the instruction from the Department of Education to me that states I need to publish on my website a statement of British values, particularly as I don't know what they are.
Well, the older I get, well, various things happen as you get older, don't they? So for a start, the headmasters look younger.
Thank you. like the
first ministers and so on. But the other thing that seems to happen for me is that as I get older, the more I see life as a sort of Renaissance painting, but with layer upon layer of irony where the paint should be, right? So we have a government that proposes to scrap the Human Rights Act that I've been talking to you about, which in turn incorporates the European Convention on Human Rights, which was promoted by people like Churchill and René Cassin, etc., in post-war Europe. There's a bulwark against Bolshevism and fascism, and the government wants to scrap those instruments, but then wants you to find something else to put on your website about so-called British values. Now, to my mind, and I have been to conferences on Britishness and all that kind of stuff, because it's a platform for debate. To my mind, the beauty of something like the European Convention on Human Rights is that it is both British and European and truly universal. And you will find those values that I set out replicated in post-colonial, post-war bills of rights and written constitutions all over the world. So the possibility that we can have, I believe in multiple identity, you see, as the reality of the human experience. So I consider myself British, but I'm ultimately human. But obviously my parents came from India, so I have that aspect to my identity. I'm a recovering lawyer. I'm a Londoner, but I like Hull. I can have all these different aspects to my identity, and equally, I think it's potentially possible to have a sense of nationhood which isn't inward-looking and xenophobic. And I can't think of a better start than something like the Human Rights Act. So this government that wants you to pontificate about British values also wants to take them from you.
We did have someone at the front who had their hand up. Maybe that one and one more.
I'm a former teacher and trade unionist, and there's two things that are really worrying me. Well, many things that are worrying me in education, but two things I appreciate your thoughts on. One of them is Morgan's idea to use children's national insurance numbers to work out which subjects get them better grades and will earn them more money when they're older. One of her latest ideas that you can track children through their national insurance numbers and then work out if they do a GCSE in science, they're going to earn lots of money when they're older. And the other one is the trade union bill and the lead picketers having to have armbands and how much of an infringement, and the trade unions having to give in advance the materials that they're going to use for strikes and inform them of the whole social media campaign before the strike actually happens. Just wondered what thoughts were.
Well, on the trade union bill is one of the biggest attacks on rights and freedoms in this Parliament, and it's part of a broader agenda, which I'm afraid is a government that doesn't like challenge very much.
Yeah.
So it's kind of strange again, isn't it? Because we're in this lovely kind of thoughtful bubble where we're talking about creating even more freedom in places that are traditionally quite hierarchical, and how can we create more democratic space and more empowerment for people in education. But actually, back in Westminster, you've got a ruling elite that just doesn't like challenge. No wonder they want to take To Kill a Mockingbird off the curriculum. They don't like to be challenged, and you see that. The trade union bill is one manifestation of that, and I have said that I consider it ideological and spiteful, and it would have not just Churchill but Disraeli spinning in their graves. And then these gentlemen have been spinning for some time, I think. But David Davis, who is a Tory and is even a Brexiteer, he has compared it to which great dictator was it that he? Anyway, Franco. This is worthy of Franco. That's his words, not mine. It's spiteful. It's ideological. It's unions. They're going to break the unions. It's unfinished business from the 80s. But it's not just unions. They attack lawyers and judges. Our Prime Minister has talked of feeling physically sick. Physically sick, not metaphorically sick, you understand. Physically sick at the judgments of unelected judges when they in particular said that the blanket ban on all prisoners voting in the UK is disproportionate, and just asked the UK Parliament to reconsider what had been an age-old, basically a Victorian blanket ban on prisoners voting that goes back to the concept of civic death, right? So the Court of Human Rights in Strasbourg just really got into a dialogue, really, with the UK Parliament about that, and Mr Cameron decided to make hay by saying he felt physically sick at the judgment of unelected judges. You're going to elect the judges now, and elect the referees. So the team that is currently top of the Premier League gets to appoint its own referee. I don't know. And we've got curbs up. We're now told that charities that receive some government funding for service provision will be subject to no advocacy clauses. Right? So say you're a big, I don't know, refugee council or something like that, and you're getting government money in order to look after refugees, then in your grant letter there'll be a no advocacy clause, so you won't then be able to speak up for those refugees. And so on and so on. So I'm afraid that we've got a very authoritarian government, and we've had very authoritarian politics actually in this country for some years. It started under New Labour, there's no question about that. And thank goodness, actually, in a way, for trade unions who have actually stood with liberty on lots of the big civil liberties issues for many years, even when the two main parties were really kind of authoritarian arms race.
One more question? Yep, from that corner.
I just wondering what your thoughts were in regards to schools taking the lead on teaching children about human rights.
Well, obviously, I would love to see schools and teachers empowering children with their human rights. And by the way, I'm not talking about propaganda or indoctrination. I'm just talking about telling people the history of their, where these human rights came from. Out of the Holocaust and the Blitz and various freedom struggles around the world. Different struggles, different histories, and just telling them what the rights and freedoms are. Just setting them out so they know what their rights and freedoms are. And then I think a really good way of approaching it is to give them problems and scenarios and let them argue about what the right decision or policy is. And I personally take a very different approach when I'm speaking in primary school to when I'm speaking in a university. When I come to a place like this or even speak to undergraduates, I will set out the rights and freedoms and then say what I think. And I will say that I think the current surveillance bill is outrageous and why, etc., but I don't do that when I'm speaking to younger audiences. I set out the rights and freedoms and then try and encourage them to have a debate about what the right balance is between privacy and security and so on. And there's no reason why that approach, which is not a party political approach, but is, I hope, a good empowerment approach, shouldn't be adopted. But of course, under the coalition government, there was an attempt to take human rights out even of the citizenship aspect of education. I think maybe the Lib Dems put up a bit of a fight and it's sort of still there, but I'm not sure how. I think it's very, very different in different places when it comes to application.
We've got a lot of questions, but unfortunately we're running out of time, and we've cut into the coffee break a little bit. Shami's going to be signing copies of her book at the back there if you would like to buy a copy of On Liberty, which I completely recommend to you. I just want to say a huge thank you to Shami for coming, for a fantastic engagement.